With respect to its argument that Bala's sentence is manifestly inadequate when compared to the sentences imposed in other similar cases, the Appeals Chamber considers that the prosecution fails to demonstrate the commission of a discernible error by the trial chamber. Finally, the prosecution submits that the trial chamber erred in disregarding the vulnerability of the victims as an aggravating factor and in double counting Bala's subordinate role in mitigation of the sentence. The Appeal Chamber notes that the defenselessness of the victims was accounted for by the trial chamber in its assessment of the gravity of the crimes, and that no error was committed as a result. The Appeal Chamber finds, however, that the trial chamber did err in double counting Bala's subordinate role in mitigation of the sentence, but that this error was so slight as to be harmless. The Appeal Chamber believes that even if it had not fallen into error, the trial chamber would have arrived at the same sentence. The prosecution's second ground of appeal against Haradin Bala is so rejected. I will now turn to the prosecution's appeal regarding Fatmir Limaj's acquittal. Under its first ground of appeal, the prosecution argues that the trial chamber erred in law and in fact by taking a piecemeal approach to the evaluation of evidence that did not have to be proven beyond reasonable doubt, and by applying a standard of proof beyond any doubt instead of a standard of proof beyond reasonable doubt. It submits that, as a result, the trial chamber erred in not finding that Limaj personally participated in the operation of the Lapušnik prison camp. The Appeal Chamber finds that it was on the basis of the totality of the evidence that the trial chamber found that the prosecution had failed to establish Limaj's personal participation in the prison camp rather than on the basis of a piecemeal evaluation of the evidence, as argued by the prosecution. The Appeal Chamber further dismisses the prosecution's argument that the trial chamber erred in applying a higher standard of proof than the standard of proof beyond reasonable doubt. The prosecution's first ground of appeal is dismissed. The prosecution's allegations that the trial chamber erred in failing to consider Limaj's alleged command position and his ability to make release decisions in examining whether he personally participated in the prison camp will be addressed under the second ground of appeal. Under its second ground of appeal, the prosecution argues that the trial chamber erred in law by misapplying the standard of proof beyond reasonable doubt and erred, in fact, by failing to consider and erroneously evaluating all the evidence pertaining to Limaj's alleged command position over the KLA in the Lapušnik prison camp. With respect to the trial chamber's alleged failure to consider the evidence of eyewitnesses in the camp as relevant to Limaj's command functions rather than solely to the question of identification, the Appeal Chamber notes that the trial chamber did in fact refer to the identification evidence when addressing Limaj's position of command and control. With regard to the trial chamber's alleged failure to properly evaluate the relevant evidence, for the reason given in the judgment, the Appeal Chamber finds that the prosecution's submissions are insufficient to call into question the reasonableness of the trial chamber's finding. Lastly, the prosecution's further submission that the trial chamber erred in its evaluation of evidence that Limaj disarmed soldiers and consequently erred by unreasonably concluding that this did not demonstrate an exercise of his command authority is also dismissed. The Appeal Chamber is satisfied that the trial chamber reasonably found that Limaj did not have powers of discipline in the sense of effective control when disarming subordinates as required for criminal responsibility pursuant to Article 7.3 of the statute. The Appeal Chamber is satisfied that the trial chamber did not err in applying the standard of proof beyond reasonable doubt to the totality of the evidence, and finds that the trial chamber reasonably found that Limaj does not incur criminal responsibility for any of the offenses charged in the indictment, whether under Code 7.1 or 7.3 of the statute. As a result, the appeal chamber dismisses the remainder of the prosecution's first ground of appeal and its second ground of appeal. Finally, the appeal chamber recalls that the prosecution's submissions under the third ground of appeal pertaining to Limaj's alleged participation in a systemic joint criminal enterprise have already been addressed, together with the prosecution's first ground of appeal in relation to Bala. As a result, the prosecution's allegation under the third ground of appeal in relation to Fatmir Limaj have already been disposed of. I will now turn to the prosecution's appeal against the acquittal of Isak Musliu. Under its first ground of appeal, the prosecution submits that the trial chamber's piecemeal approach to the evaluation of the evidence on Isak Musliu's participation in the camp was legally erroneous. The prosecution argues in particular that the trial chamber erroneously restricted its evaluation of his participation in the camp to a limited portion of the evidence, namely direct visual identification evidence. The appeal chamber notes, however, that in addition to visual identification evidence, the trial chamber took into account witness testimonies that Isak Musliu was at the relevant time known as Kerkits, that certain prisoners heard his name while they were beaten, and that a person called Kerkits was almost continuously present in the camp between around 28 June and around 23 July 98. The appeal chamber therefore rejects the argument that the trial chamber applied a piecemeal approach to the evidence. The prosecution further submits that the trial chamber erred in law by failing to apply the standard of proof beyond a reasonable doubt, and instead applied a standard that entertained any doubt, including doubt not based upon evidence, logic, or common sense. Furthermore, the prosecution argues that the trial chamber erred in fact by failing to properly consider relevant evidence on Musliu's participation in the prison camp. The appeal chamber examined whether the trial chamber erred in rejecting the evidence of several witnesses which identified a person who went by the pseudonym Kerkits in the prison camp. With respect to Rushdie Karputz's testimony on this issue, the appeal chamber considers that he saw Isak Musliu inside the prison camp and not only heard him as held by the trial chamber. However, the appeal chamber finds Judge Schomburg dissenting that even if Isak Musliu had been singing inside the camp, the prosecution had not shown that this would have made it unreasonable for the trial chamber not to find that he was responsible for crime committed in the camp. The prosecution further submits that the trial chamber erred in failing to find from the cumulative evidence of witnesses L10, L4, and L12 that Isak Musliu was identified inside the camp. In relation to witness L10, the trial chamber held that while he stated that he identified Kerkits in the prison camp as the, I quote, masked perpetrator, end of quote, who was addressed by Shala as Kerkits, witness L10 also, I quote, acknowledged that he could not distinguish Kerkits from the other soldiers at the camp because of the mask he wore, end of quote. Thus, the appeal chamber finds, Judge Schomburg dissenting, that the trial chamber reasonably held that he could not conclude from witness L10's evidence that Musliu was in fact the man witness L10 knew as Kerkits. With respect to the remaining witnesses, the appeal chamber finds that the trial chamber reasonably held that witness L4's testimony did not provide a reliable basis for a finding that Musliu participated in the operation of the prison camp, and that he reasonably refrained from finding on the basis of witness L12's testimony that Musliu was present when he was beaten in the camp. In sum, the Imperial Chamber is not satisfied, Judge Schomburg dissenting, with respect to the evidence of Rushdie Karpuzis and witness L10, that the trial chamber erred when it did not conclude from the testimonies of the above-mentioned witnesses that they identified Musliu in the prison camp. With respect to the testimonies of witnesses L64 and L96, who allegedly saw Kerkits entering the prison camp and inside the prison camp, respectively, the Appeal Chamber recalls that the trial chamber reasonably held that their evidence had to be independently confirmed in some material particular. Since the trial chamber reasonably rejected the evidence of witnesses L10, L4, and L12 on having seen Kerkits or Musliu inside the camp, the relevant evidence of witness L64 and L96 was unsupported and thus reasonably rejected. Finally, the prosecution submits that the trial chamber unreasonably failed to consider evidence of Musliu's near continuous presence in the village of Lapušnik and his proximity to the camp. In light of the above findings on the witnesses' testimonies, however, the Appeal Chamber is satisfied that it was open to a reasonable trier of fact to find that the close proximity to the prison camp alone does not support the inference that Musliu was present and personally participated in its operation. In sum, the Appeal Chamber is satisfied, Judge Schomburg dissenting, that notwithstanding some minor errors in the trial chamber's reasoning which do not have an impact on the verdict, the trial chamber reasonably assessed the totality of the evidence and found that Musliu was not present inside the prison camp and did not participate in the operation of the Lapušnik prison camp.